special immigration show with attorney Mr. Parvathaneni from Managing Attorney at law firm of Parvathaneni and Brown. Please know that Sakshi TV now has three immigration shows every week. At Thursdays at 5 p.m. EST with attorney Chands Parvathaneni, on Wednesdays at 5:30 p.m. EST with attorney Prashanti Reddy, and on Fridays at 6 p.m. EST with Banu and Indra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 8667257441. Before we begin the show, please note that the information provided on this show is not legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any specific legal advice, you can contact the attorney directly. Mr. Chan needs no introduction, but if you need any specific consultation, please log on to spblawfirm.com for contact information. When you connect with them, don't forget to mention Sakshi TV. From the beginning, spblawfirm.com site has provided a wealth of free information and online tools in the hands of immigrant communities and for the benefit of US employers. The www.spblawfirm.com site provides you with the latest cutting-edge information on US immigration laws and policies explained in terms you do not have to be a lawyer to be understand. So we will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. Before we get into the topic, you can call us on the numbers of the screens and ask questions. So today's topic is various complaints, issues, and requirements for the H1B visas. So without any further delay, let's welcome Mr. Chand. Hello, Mr. Chand. I hope you're doing well.
Hello, Shivani. Pretty good. Thank you so much. And hello, all Sakshi TV viewers.
Yes. So, Mr. Chand, I was wondering if you can talk a little bit about your law firm and what you do, and so that the viewers can, get more interested and maybe come for a consultation.
So, I've been practicing law since 2011. It's more than a decade that I've been in the immigration practice. So, as an attorney, I typically represent a lot of IT companies, and most of my practice is working with corporations, IT corporations. Don't do a lot of work directly for individuals, and it's typically employment-based immigration that I have been associated with. And as a part of my work with employment-based immigration, we work all across US. We work with companies that require very high-tech talent from all over the world. And at this point of time, there is a lot of talent in India. There is a severe backlog in US, and everybody knows about it. We don't have enough people in US. We don't have enough specialty occupation workers. So when I say specialty occupation, these are high-tech jobs, not something that anybody can do. Somebody that has to go through a rigorous college education. So those kind of jobs, there is a severe shortage in US. And luckily, as a part of my work, I get to deal with such high talented folks from various countries, and the majority of my filings are from India. And the reason for that is H1B as a program. This H1B the H1B visas, they are typically utilized by Indian nationals. Most of the employees in H1B program, they are typically Indians. We have a lot of talent in India, and that explains why H1B visas are mostly used by Indian nationals. So that's pretty much what I do. In terms of my volume, it's a couple of thousands of H1s a year. And in the recent H1B cap season, I was fortunate enough to represent over 2,100 H1B filings. So in terms of the volume, that's the kind of volume we deal with. And that has given us a lot of insight, a lot of data on what is happening with USCIS, what kind of approvals we are seeing, what kind of issues we are seeing. And it helps us use that data to make sure that the filings or the advice we give our clients, various corporations, we assist them, because the goal is to ensure that the companies hire the best and the brightest, and at the same time, they don't spend a lot of time in dealing with the government. We try to make the process as quick as possible, as short as possible, by making this process as smooth as possible while they deal with the US government to get their work authorizations before the H1B employees can start working for their companies.
Yes. So, Mr. Chan, let's get on to our topic for now. So, Mr. Chan, are there any recent visa updates or immigration updates that the viewers must know before we get on to the topic?
Sure. So the main update this month is a shocking retrogression that we saw in the October bulletin. So US CIS, they stated that they've used all the visa numbers for this year. So for 2022 fiscal year. So the fiscal year that ends on September 30th, all the visa numbers are used up. And what that means is no more green cards in 2022 until September 30th for EB1 and EB2 categories. But however, the welcoming news is that they have issued 281,000 green cards this year, and that's a record number. We have never seen USCIS issue so many green cards in employment-based category. And the other good news is that the major beneficiaries of this record number issuance, the 281,000 green cards, the major beneficiaries are Indian nationals. And the reason why majority are Indian nationals is because India is the only country which is so severely disadvantaged because of the 7% country quotas. And because of the 7% country quotas, India has the most severe backlog. So it is this reason why Indians were the maximum beneficiaries in this year's green card issuance. So in one way, a lot of backlog has been cleared. And the unfortunate news is that we have retrogression. It is very, very unfortunate. It is going to cause a lot of anxiety to a lot of people who are waiting for a green card. But the good news is a lot of backlog has been cleared. And what that means is starting October 1st, we will see the new visa numbers fall back in. So USCIS will be able to start issuing green cards. And we might also have some spillover. And all this will again start clearing out the backlog. And hopefully, whoever is waiting after filing their 485s, they will probably start seeing green cards in the next fiscal year that will start on October 1st. And in terms of the dates, so the EB2 dates and the EB3 dates, both of them are now at the same point. So the date is April 1st, 2012. And as of today, in the new visa bulletin starting from October 1st, both EB2 and EB3 will be at the same point, same priority date. However, if you look at the second chart, the data filing chart. So in the second chart, after a long time, EB3 went ahead of EB2. So in a way, that's a good sign because at least EB3 is not retrogressing. EB3 is moving ahead. And hopefully EB2, we will see some good days once we see the following month's visa bulletins.
Yes. So, what exactly is a compliance and how is this context very much related to the H1B?
Especially when you're dealing with the government. So, compliance is basically ensuring that we are conforming to all the laws of the country, conforming to all the laws of the state, and conforming to the laws of the local authorities. So US follows a federal system. So a federal system is where the federal government. So in India we call it the central government. Here in US we call it the federal government. So in a federal system we have the federal government making laws. We also have the state governments making laws. So we have a federal government, we have a state government. Both of them make laws, and depending on what the issue is, sometimes the state has that right to make the law. Sometimes the federal government has the right to make the law. So this is a very successful system, the federal system. And in US, there is a very, very good demarcation and on who makes the laws. For example, marriage, divorce, property. Anytime it's a question concerning a marriage, question concerning the validity of a marriage, question concerning the validity of a divorce, or property, or some crimes in the state. So all of these are state subjects. So the state government will make a law. And what that means is in Texas, you can have a different law for how one gets a divorce. And in California, they can make their own laws on how they will grant a divorce. Same thing with property, with wills, with the criminal laws. So every state has their own way of making laws. and the federal government typically will not get involved. And then you have some matters which are for the federal government. For example, you have the defense, you have immigration. So immigration is always a federal subject. So anything to do with immigration, it's always the federal government that will make the law, not the local government, not the state government. In the immigration world, immigration comes under the federal government. So the federal government will always make laws about immigration. However, when you're looking at the immigration contest, the context, the H1B context, or say the student statuses, F1 status, F1 context, even though you're looking at the immigration aspect, one always has to comply with all laws. One has to comply with the federal laws, one has to comply with the state laws, one has to comply with the local city laws. So what that means is the local city, for example, will have ordinances. For example, in state of Texas, lighting firecrackers is legal in state of Texas, so one can do firecrackers. However, in the local cities, they have ordinances where they say you cannot do fireworks in the local city limits. So one has to make sure, even if you have multiple laws, you always have to ensure you comply with all the laws. You comply with the city law, you comply with the state law, you comply with the federal law. So compliance is all about making sure we are following what the laws of the land ask us to do, which is follow the federal laws, follow the state laws, follow the local city laws. And as an immigrant, as somebody who's an immigrant, even a simple criminal offense or even a simple, sometimes a non-criminal offense can have major repercussions. So what it means is know the laws, follow the laws, because ignorance of law is not even an option. It is not even a defense. One cannot go and say, I did not know that such a law exists, and that's why I did not follow that law. Ignorance of law is not an option. So that is true in many democracies. It is true in US. It is also true in India. One cannot say that I did not know that a law exists and follow against the law. One has to always follow the law. And what that means is you comply with the law, and that should be a part and parcel of everybody's day-to-day work.
Yes. So, Mr. Chan, what are the compliance requirements for an employee who is working on the H1B visa?
There are many requirements, and due to the way the laws are so complex, I'll not touch everything, but I'll look at a few important compliance requirements. So when somebody is a H1B employee, some of the things are always expected, and one should know these rules. So from a employee perspective, as a H1B visa holder, one always has to make sure about certain things. The first thing is making sure, as a H1B visa holder, they are working in the occupation that they're required to work in. So in order for somebody to get on H1B visa, the employer will always file a H1B petition. So the H1B petition will say, and it will state the occupation that the employee will work as. So if the H1B petition says the employee will work as a software developer, the employee can only work as a software developer. The employee cannot work as a database administrator. The employee cannot work as, for example, IT project manager. They cannot work as a restaurant manager. They cannot work on any other job except in the occupation that they were required to work in. So whatever their H1B petition says their occupation is, that is the occupation that one should work. They should not work in any other occupation. That is very, very important. If they have to change their occupation, they have to talk to their employer. They have to make sure their employer notifies USCIS and follows the process. So that is very important. Work only in the occupation that you're required to work in. Number one. Number two, the work location. So the H1B visa holder, they should only work from the location they're allowed to work at. So every employee, they will get a copy of their LCA. They are required to get a copy of their LCA from their employer. The employer has to release that document to the employee. And by looking at the LCA, the employee can know what is their work location. So it is very important that every employee that is working on H1B status in United States, they take a look at their LCA copy. They look at their work location. They have to ensure that they're complying with that work location requirement. If they need to work from a different location, make sure that H1B employee talks to the employer. If in doubt, talk to an attorney, but always make sure you do not violate the work location requirement. That is very, very important. The next major thing is sitting on the bench and getting paid as required. Uh, some employers, unfortunately, if the employees are not in productive status, they're not on a project, they put them on the bench. And what bench means is they're saying, hey, stay at home, don't come to work, and we will not pay you. That is not permitted. One cannot be put on the bench. One has to be paid at all times, and one has to work at all times. So getting paid and working at all times, it's a very important requirement. And if in doubt, consult an attorney. So one has to make sure they take a look at their LCA filing, because that LCA document will tell how much that employee should get paid. It is highly critical that employee does not sit on the bench and employee is getting paid as required. That is very, very critical. And next most important thing is doing a second job or doing something else. So lately, because of labor shortages, many people are tempted to take up a second job or tempted to start up another business and work for their own business. One should never work without authorization. USCIS does permit a person to take up a second job. If somebody wants to do a second job, there are ways to do it. So go through your employer or talk to an attorney, but do not do a second job or any kind of work without authorization. It is very, very important. If one ever gets caught working without authorization, it will impact their future green card process. It will impact their future H1Bs. So very, very important. Do not do a second job without proper authorization. If one needs to do a second job, yes, you can do it. Go through, follow the proper process. And the next thing is staying in the country. One, the H1B visa is a non-immigrant visa. So typically it is given for 3 years at a time. One has to make sure that they do not exceed staying in the country beyond their authorized stay. So if one needs to extend their stay, they have to extend their H1B before the H1B expires. So always apply for a H1B extension before H1B expires. If once H1B expires, you're out of status. So the very important rule is always pay attention to your I-94. Look at your I-94, the end date. Do not stay in the country once your I-94 expires. Always make sure you file your extension before the I-94 expires. That is very, very important thing. And the last important thing is pay taxes on time. Very, very important. Do not ever forget to file taxes. Always pay taxes on time. Occasionally, we see RFEs for tax returns. It is a very common RFE. And also during your green card process, USCIS could ask for the tax returns. Sometimes even at the consulates, at the visa interviews, somebody can ask for a tax return. So make sure one always files the taxes on time. Do not neglect the filing of the tax returns. So overall,
Yes.
these are the points that one should always keep in mind.
So, Mr. Chan, now that we've spoken about the employees, what are some requirements that the employers must go through, and also when they're hiring new employees for the H1B?
By participating in the H1B program, the employers have a big burden. So by utilizing the H1B program, the employers also have the burden that they comply with the laws. So there are severe repercussions if one does not comply with the laws, and the employer has to ensure that they are doing a couple of things to ensure that they are in compliance of the H1B program. When an employer files a H1B petition, they attest to a bunch of things, and when they attest to all these things, they're attesting under perjury of penalty. So it is highly important that they review what they're signing and follow certain things. And those certain things, I'll walk through certain important things. The LCA. So the LCA compliance is a very, very important step, and filing of an LCA, it is the first step in the H1B filing. So in order to file a H1B, the LCA has to be filed. So that is the very first step. So filing LCA is the first step, but when the minute the employer files a LCA, the employer is attesting to a bunch of things, and it is very important that the employer understand that they are required to pay a wage that is required by DOL. So the wage attestation is very, very critical. they are also making numerous statements. They have to make sure that all the statements are true and accurate. And one also has posting requirements. Every LCA has posting requirement. One has to post it on the notice board for 10 days. This is very, very important. So one has to ensure that all the LCA compliance needs are met. That is very important step. The second step is material changes. Anytime anybody files a H1B petition, the employer is telling USCIS that my employer will work from so and so location. He will work and perform so and so duties in so and so occupation, and a couple of things. Anytime there is a material change, when I say material change, a major salary difference, a major work location change, or the duties are changing. So anytime there is a material change, the employer has to immediately notify USCIS. There is something called an amendment filing, and the employer has to ensure that an amendment is filed. And through an amendment filing, the employer is required to notify USCIS. So this is very, very important. Anytime there is a material change, notify USCIS. Otherwise, if there is a site visit, employer might run into some trouble. So to avoid all those issues, notify USCIS. Next major thing is I-9 compliance. I-9 compliance is super important. And if the employer is not complying with the I-9 and there is some kind of an audit and they find out that I-9 compliance is not there with the company, there are severe penalties. The penalties for I-9 are huge. So I-9 compliance is very, very important. And from an employer perspective, what that means is anytime they hire a new employee, they have to make sure they fill up the I-9, properly complete the I-9, and save it in their records. Because anytime there is an audit or a check, if USCIS discovers that they are not complying with I-9, severe penalties. So any employer in US, they are required to maintain I-9s. That is probably one of the most important requirements for any employer. And then other minor things. Termination of employment. If an H1B employee is terminated, so the job ends, the employer does not want that H1B employee anymore. They are required to terminate employment, notify the employee, and not only that, they are supposed to notify USCIS. They have to let USCIS know that they want to withdraw that H1B petition, and only by doing so they stop the liability. If they do not notify USCIS, they might have a pay liability. So it is very critical that anytime an employee is terminated, the employer is immediately notifying USCIS. Not only that, they're also supposed to go back to the employee and offer return airfare. So if somebody is from India, they're supposed to offer them a flight ticket to India if their employment is terminated. This is very important. If they're not offering the return airfare to the country, the country of residence, then they have a compliance problem. So anytime a H1B employee is terminated, make sure the return airfare is offered to the employee. And the last but not the least, benching. Some employers try to misuse H1B program by benching. Benching is strictly prohibited. And what benching means is, if the employee does not have work, you cannot tell your employee to stay home and say, I will not pay you, stay home. If your employee does not have work, you are required to notify USCIS and withdraw the H1B. You cannot have an employee sit at home and not pay the employee, because that is benching, and benching is prohibited. If DOL or USCIS finds out about it, they will make you back pay those wages, and that will be a very expensive thing to do. So the best thing is do not bench, and just follow all these compliance things. That way, the employer will be in a good shape. We should not have any issues with the US government.
Yes. Thank you so much, Mr. Chand, for joining on to our show. I think we covered again many different topics today. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.